Hello everyone, welcome to module 8. In this module, I'm going to give you actual prompt templates you can adapt for the two most common high stakes writing tasks you face as law students, which is moot court memorials and exam answer writing, as you can see on your screens right now. Think of these as starter templates. You will customize them for your own specific needs, but the structure gives you a proven framework. Let's start with the moot court preparation on the left side of your screens. Moots are intense. You're researching complex constitutional or international law issues, building sophisticated arguments, and you're usually under tight time pressure. Right. So here are three ways AI can assist ethically in your moot preparation. First, as a research assistant. Uh, I'm going to read out the prompt for you aloud, or you can also pause and read it for yourself. It is that I'm preparing for a national moot court competition on constitutional law, acting as a legal research assistant. See, this time the role is to act as a legal research assistant, not as a professor or a practicing lawyer. Identify leading Supreme Court cases on Article 21, right to privacy, decided between. Now we are telling it that we want the case in a certain time frame, not from the starting of the era, or not from the when the constitution was launched, 1950. We don't want the cases from 1950. We want the cases from 2015 to 2024. Okay, so for each case, provide. Now we are telling it the format: case name and citation, one line holding relevant to data protection, present as a numbered list organized chronologically. See, we are telling it the format should be, it should be presented as a numbered list which should organize chronologically, which means by the date. It's not like कि सबसे पहले आपने 2025 का बता दिया, फिर 2023 का बता दिया, फिर 2024 का बता दिया. No, if I'm asking from 2015 to 2024, so if there's any case in 2015, first comes the case in 2015, then comes the case in 16. If there's no case in 17, then the 18th case, then 25, right? In a chronological order. Okay, so what this prompt gives you, it gives you a comprehensive case list really quickly, right, in 30 seconds. Okay. Instead of spending 2 hours running different search queries, and after that you curate a list of 30 something cases, right? But in this case, in 30 seconds, you get a list. But remember, always remember that you still must verify every citation in a legal database on Indian Kanun, like the simplest is on Indian Kanun, you can check it, right? And read the full judgment as well, not just the AI summaries. Like if it is saying that this case was in 2015, the Supreme Court said this and this in this case, go to the judgment and check if the case really says that. And to be more precise, like if you want to save more time, you can also go to CaseMine as well. In CaseMine, most of the cases, without subscription as well, most of the cases, when you put the case name and the case opens, you can open it. And in the judgment, before the judgment, there is this part where they give you a case summary as well. Like what exactly happened in this case is in a really, like, judgments can be pages long, like 3 page, 4 page, 5 page long. So there's also a way of reading a judgment which is not, without tiring yourself and boring yourself. But you can also read that summary as well. If you're in a hurry, you can read that summary on the before the judgment as well, and know what actually is being said. And if you want to file any quoted lines, then obviously you have to go to the judgment and read the whole thing and to find where that line actually is. Okay. So after that, understand the reasoning and how cases related to each other, right? In that list, how the cases are related to each other, and develop your own analysis of how these cases support your argument. Okay, in the mood proposal, in mood memorial, if you have certain situation and you use the AI as a research assistant, it gives you let's assume 10 cases. Okay, 10 cases. It gives you 10 cases. Now all the cases are related to Article 21, right to privacy, obviously, because it is giving it, if they are all verified and correct, not the hallucinated ones. Then it does not mean that all the 10 will be of any use to you. in your mood proposition, because your situation of the hypothetical research problem that you have got in the mood proposition, uh, that depends, like might be two cases of the 10, two cases might you be able to use as your own argument. Some of it might be used as the opposing counsel. It will be of no use to you, but to your opposing counsel. So it might be that out of 10 you just get to use like one or two, right? So it happens. So you have to read the judgment to know what is in your favor and what is not. And even if it's not in favor, you have to read it because the opposing counsel might present it, and then you have to defend it. Okay. Now, second, you can use AI for the issue identification. See, when you first get a moot proposition, it's often complex and multiple overlapping legal issues are there. So it's easy to miss something critical, right? So you can give this prompt. I will read it out loud. I am a third year law student preparing a moot memorial based on the following proposition. Just to give the brief summary of the brief summary, I mean by that, just copy the whole proposition and paste it. If you have not made any notes of yours, just copy the whole proposition, paste it here in the brief summary brackets, and then this is for the constitutional law competition under the Indian jurisdiction, acting as a moot preparation coach. See, here the role is as the moot preparation coach. Identify all the constitutional provision implicated specific legal issues the court would need to determine, and at the last, format. What format it should present the output in the organized as two separate sections with bullet points. See, in bullet points, the benefit is that you don't have to read the whole paragraph again and again. In bullet points, it is easier for you to remember as well, and to find, like, if you're working on the case down the line, in mood proposition, obviously working the case, and suddenly you remember that this certain fact was there, and I don't remember the exact line that the victim or the complainant said in that situation, which was in the facts in the mood proposition. So you don't have to go back and read whole 3 4 5 pages mood proposition. There's a bullet points, and it is arranged chronologically, so you can just go and check, oh, this is what she said. So it saves you time, right? Instead of reading the whole thing, because you cannot remember every single line where it was when you first read it. Okay, so now you know with the bullet point that here it is, now I can read it. Okay, so it helps you to ensure that you have identified all the issues. Like this issue identification thing would help you to identify all the issues, not just the obvious ones which you can see. First reading, you can identify few issues are there, but there are certain also issues that can be framed which you might miss because you're just lost in that time. Okay, so this will help you to identify those issues as well. So the judges in the moot competition often penalize you heavily for missing a critical issue as well. Like you get your points cut if you don't point out to any critical issue, or you don't raise any critical objection or anything. So they cut points on that as well. So this prompt acts as a comprehensive check for you. Okay. Now, moving to the third, which is a precedent analysis. See, understanding doctrinal evolution is crucial for sophisticated moot arguments, especially in constitutional law. Uh, read the prompt for, sorry, let me just read the prompt. For a moot memorial on privacy rights under the Indian constitutional law, I need to understand doctrinal evolution. Acting as a constitutional law expert, compare the reasoning in Puttaswamy versus Union of India 2017 case with early privacy jurisprudence, specifically identifying what early cases established, how Puttaswamy changed or expanded the doctrine, and key shifts in judicial reasoning. Present as earlier position, Puttaswamy contribution, then doctrinal shift. So it helps you to understand what the earlier position was before Puttaswamy, what changes does Puttaswamy case brought, and what doctrinal shift it led to. Like all the three things in a chronological way. So it is easy for you to understand. Now, tell me, this will be easy for you to understand, or just reading an article from the internet which tells the same thing, the same thing that you're asking here, it explains the same thing but in 20 paragraphs. Tell me, which one will be will you remember easily? The 20 paragraphs or the AI output where it has just pointed, like you have to verify obviously. But in a it will you will have that in a clean format. And then you know that the first two paragraphs are your early positions, and then you have the Puttaswamy contributions, and then you have the doctrinal shift. And it is for like students, so you for more preparation. So it is made in a not in a heavy legal jargon language, but in a easy language. Okay. So this helps. This will help you to understand how the law evolved, right? What earlier cases said, then what the Puttaswamy changed, and why this the shift occurred, and all. Okay. But again, AI gives you the framework of evolution. You still need to read the actual cases and understand the judicial reasoning for yourself. Because see, you cannot always rely on AIs. You have to read cases, the actual case files. Because in the court you बैठे रहो और फिर सब कुछ AI से पूछो यार अब क्या करें अब क्या करें अब क्या करें. No, you have your AI is to help you ease your to save your time. Just what interns and your junior associates do for you. Just move faster than them, right? But they're not there to do your work. You have to know how to read files. You have to know how to analyze a case by reading it. You should know how to read a judgment effectively, right? You should know all these things. AI is just there to lend you an helping hand. That's it. Okay. Now, coming to the answer writing section on the right side of your screen. So let's talk about exam preparations where time pressure is even more intense and you need to demonstrate understanding real quickly. So for that, first is your question analysis. See, one of the hardest exam skill is understand what the examiner actually wants. So you can just get any previous year question papers from your seniors and you can do a question analysis of that as well. You can use this prompt that I'm a second year law student or whichever year law student you are taking a contract law exam. Here is an exam question. Just insert the question. Acting as an exam strategy tutor, analyze. First, which specific legal principle the examiner is testing. Second, what structure would comprehensively address all issues raised in the question? And the third, what common mistakes students make on questions like this? Now, present as three separate sections. Like three separate sections because 1, 2, 3 you have asked, so you are asked the AI to present as a three separate sections. Okay. Now this helps you to decode the question. What looks like a simple contract problem might actually be testing 4 or 5 different concepts. So by using AI to analyze practice questions during your preparation helps you develop the skill of issue spotting, which is critical for actual exams. You are preparing for the actual exam by understanding the question drafted by the same teacher previous year, right? So this is important because this is for practice and preparation, not for the use during actual exams, which would be cheating obviously. But this is for practicing. Okay. Now coming to the second one, which is concept clarification. When you're studying and encounter a concept you don't fully understand, AI can provide targeted explanations as well. See, the prompt here says that I'm an undergraduate law student in India preparing for my contract law semester exam, acting as a law professor, explaining to students, explain the doctrine of frustration under Article 56 of the Indian Contract Act 1872. Cover what you to cover, you are telling it. First, the definition and rationale. Second, essential conditions for frustration to apply. Third, two practical examples showing when frustration applies and when it does not. And after that, you are telling it the format that you want it in, which is present using IRAC structure in 250 to 300 words, suitable for an exam answer. Because the at most you write 300 words for 10-mark questions, not more than that, because it will be really time consuming. And you should put it in a bullet points, not like कहानी सुनाते जा रहे पेपर में, ऐसे नहीं. बिकॉज टीचर को एक क्लास के 40 बच्चों के पेपर्स चेक करने होते हैं, तो शी इज नॉट गोइंग टू रीड योर होल स्टोरी दैट यू हैव रिटन इट. जस्ट डू इट इन पॉइंट्स so that teacher can go through your answer and see that if you have mentioned the critical things that she asked in a question or not, and then give you marks. If you have written like 5 pages, long, like continually लिखे जा रहे हो, paragraph wise लिखे जा रहे हो, teacher would be bored, because it will be difficult for her to in 5 pages spot the critical thing that she asked in the question. And even after 5 pages, she does not find that, and she finds everything else and not the exact answer that she was looking for. It would affect the other answers as well, because if you written the other answers in the same manner, she will think that you're just wasting her time. So she will just skim through it and give you give you low marks. So always write your answers in bullet points, in short points. And even if you're writing in a paragraph, just use a pencil and underline the main point of that. Like, is that the, and there will be so many things in that paragraph, but the critical thing which you're trying to convey with that paragraph, just underline that, so the teacher's going through your paragraph. No, okay, okay, so he mentioned that, okay, because she had a lot of copies to check, they have other works to do, so she's not there to read your 6 questions, 5 pages each in paragraph form. Okay, make her work a little easy. So now you the second concept clarification prompt that you notice. It asks specifically for student appropriate explanations, right? Not like practitioner level complexity nahi chahiye hame. We are asking for student appropriate explanation in layman terms. Second is exam suitable format, IREC structure, which to be of appropriate length you're asking for. Then practical examples, so you can understand application, not just theory. Because sometimes in BERECs as well, when there's a few things written in BEREC, but in the starting you just don't you it is really difficult to understand the BEREC language. But we get the clarification by reading the examples of that. So when you read the examples given in that, right, for any criminal intimidation, for example, when you read the Barak language, you might find it really intimidating or not understanding the first instance. But when you read the illustrations given under that, you understand in the first instance, like it's in easy language and it's something relatable. Like you can understand, like somebody came, A came, B came, it said some things which like if intimidating and like something like that, right? Examples, I cannot remember the exact one, but yeah, you understand what I mean, right? So now this is using the concept clarification prompt. This is using AI as a study aid, like using a textbook or asking a professor to explain something, but more targeted to exactly what you need to understand, right? Say third is your case law recall. Just a yes, case law recall. Exams often require you to cite relevant cases quickly, but with hundreds of cases covered in a semester, it's hard to remember which ones matter most in that for that question, especially, right? So for that, you can use the prompt that I'm preparing quick revision notes for my administrative law exam covering judicial review in India. Acting as a study guide compiler, list 8 to 10 landmark Supreme Court cases illustrating the evolution of judicial review standards from pre-independence to present. For each case, provide case name, year, and one line holding, organized chronologically with clear date markers. Okay. So this creates a quick reference sheet for revision. The most important cases organized chronologically with concise holdings you can memorize. So you use this during preparation, not during the exam itself. And let me emphasize something critical about all these prompts. These are for preparation and learning and not for bypassing the actual work. In moot competition, AI helps you research efficiently, but you still read cases and build arguments. AI identifies issues for you, but you still analyze and develop legal reasoning. AI shows doctrinal evolution, but you will still understand and apply precedents, right? Likewise, in exam preparation as well, AI helps you practice issue spotting, but you develop the skill yourself. By using it a few times, you develop your skill yourself. And AI clarifies concept, but you internalize the understanding. And AI creates revision aids, but you memorize and apply the knowledge. AI accelerates your learning. It does not replace learning. Okay. And here's the beautiful part. Once you have used these techniques a few times, you will start recognizing patterns. You will get better at constructing prompts on the fly for whatever specific need you have. These templates that I provide you aren't rigid rules. They are starting points you will customize and improve based on what works for you. So So here we are going to end this module, and in the next module I will show you the most common mistakes students make when using AI and how to avoid them. So I'll see you all in the next module.